If you are not legally protected in your business, you are leaving money on the table. Hey, I get it. The legal side of business can feel intimidating, but the good news is it doesn't have to be. If you want to build your business on a strong foundation, and if you want to know that your rights are protected when the unexpected happens with a client or a customer, then it's time to get legally protected. This means no more using free contracts that you downloaded off of the internet. This means partnering with a law firm that actually believes in your vision and can help you achieve it. This means legally protecting your brand so that no one can steal your good ideas. There are a lot of ways to grow and scale, but if you want to grow a strong business, it's time to get legally protected. If you're listening and resonating with this, then my signature service, the Legal Upgrade, just might be perfect for you. The Legal Upgrade is a straightforward, structured process to give your business the legal protection that it needs to thrive. Click the link in the show notes and schedule a call with me today. Hello and welcome to the Legal Upgrade Podcast. I'm your host, licensed attorney Christian Hammond. This podcast breaks down the legal side of business to reveal key legal strategies that can help you take your business to the next level. Please note that none of the following is legal, tax, investment, financial, or medical advice. Without further ado, let's get into the show. From time to time, I get a call from a business owner that goes something like this. Hey, there's someone doing something that I don't want them to be doing. Can you just write a scary letter and get them to do what I want them to do? And the answer is no, because that is not actually a winning legal strategy. And today we're going to talk about why. I think this is a really important topic because I think there's this, I'm going to call it an urban myth that lawyers can just kind of, hey, if you can get the right lawyer, if someone is not doing what you want them to be doing, just get the right lawyer, have them write a really scary letter, and that will intimidate the other person and you'll be able to get what you want. And honestly, maybe it's been actually us lawyers that have perpetuated this idea because I think, truth be told, all of us lawyers have a little bit of a savior complex. I think deep down, secretly inside, we love the idea of swooping in, cape blowing in the wind, and being able to solve your problem with just the stroke of our pen. Secretly, we love that. And maybe it's actually lawyers ourselves that have perpetuated these kinds of ideas. But it's actually, I think, really harmful for the client and potentially for the client's reputation. This idea of, oh, let's just send a scary letter and that will get us what we want. And that's because not only is that incorrect, meaning that doesn't actually work 95% of the time. 95% of the time, sending a letter is not the end of the issue. So not only is that incorrect, but it's also just not a winning strategy. And I want to talk about why, as a business owner, you can and should be approaching these types of issues from a different perspective. Now, if you're new here, welcome. My name is Christian Hammond. I'm a licensed trademark attorney based in Washington, D.C., but serving clients worldwide. And I help small businesses get legally protected. And like I said, this is something that happens from time to time. Someone calls me up, they're interested in hiring the firm. And basically what they want is for me to send a scary letter on law firm letterhead. And they are hoping/thinking that that is going to solve their problem with whoever they are dealing with. And the symptoms, or what I would say the situation, is kind of always the same, where they do have a problem. Maybe it's an unpaid invoice. Maybe it's an issue with a former disgruntled business partner or a former disgruntled employee. So they do have this legal problem, but at the same time, they don't want to commit to any full solution. They don't want to commit to litigation, which I completely understand. Litigation is not the end all be all. Litigation is not the answer to every problem. But they also don't want to commit to negotiating. Instead, they want this fast and easy insta solution. In other words, they're not committed to the outcome. And if this is the situation, if these are the symptoms of the situation, or if this is your approach to a legal issue in business, a demand letter or a cease and desist letter, those are kind of interchangeable. They basically mean the same thing. A demand letter is not actually a winning strategy in these situations. My approach, my perspective is that if you are going to send a demand letter, you need to be mentally and financially willing to take things beyond the letter if necessary. And I'm going to give you 4 reasons why I believe this is true. Reason number 1 is because savvy lawyers know better. Savvy lawyers can see right through a hastily written, not really well thought out, let's just kind of shoot from the hip and hope they cave it and do what we want kind of letter. Savvy lawyers can see right through it, and I'll actually give you an example. So I had a client, and at the time the client came to me, they were really upset, really distraught. They were coming out of a situation where first of all, they hadn't been paid. They had sent 2 invoices that had not been paid. And to make things worse, they had had a falling out with the person they were working with their client. And that client was now threatening to sue them for defamation. And so they were really upset, really worried, didn't know what to do. Well, I said, okay, let's look into this. And so I just started asking questions about what's happened. Can I see the emails? Can I see the text messages? Show me the correspondence. Show me what's going on. Let me see the dates. And so I just started asking questions and working my way through unpacking what was really happening in this situation. And by the time I finished going through everything with my client, it was clear that not only was she not guilty of defamation, but also, actually, the other person was guilty of copyright infringement, in addition to the fact that they had still not paid her invoices. So I ended up responding to the supposed cease and desist letter, which was really just a poorly written, rashly written email. I ended up responding to them and saying, hey, there's no defamation here. And also, we actually have you for copyright infringement. We could sue you for copyright infringement if we wanted to. So you need to pay these invoices. And that's what they did. So the first reason that just kind of firing off a scary lawyer letter and hoping that intimidates the other person, the first reason why that's not a winning strategy is because any savvy lawyer is going to see right through that. Any savvy lawyer is going to see that letter and know there's no real substance here. There's no real law here. They're not actually holding any chips. They're holding a big, fat nothing burger. And they're going to call your bluff. And that is not a good look. That's not what we want for you. So that's the first reason why just sending a scary letter is not a winning legal strategy. The second reason that just kind of trying to strong arm or intimidate somebody else with a demand letter from your lawyer is not a winning strategy is because there's no guarantee that intimidation is going to get you what you want. There is no guarantee that intimidation is going to get you what you want. When I was growing up, my mom would say, you catch more flies with honey than you do with vinegar. That's kind of some old school wisdom. So if you have never heard that before, this is what it means. It means that you tend to get better results out of people when you're nice to them than when you're nasty to them. You're more likely it's more likely that someone is going to do what you want them to do if you're sweet about it than if you're nasty about it. And I think that not enough business owners understand this. Not enough business owners understand the art of finesse, the skill of tact. Not enough business owners understand this fundamental wisdom. You get more flies with honey than you do with vinegar. Now, I'm not saying that there's not a reason for that. I think the reason that people lose sight of this is because when things feel personal, when emotions get involved, it's easy to lose sight of what you really want. And I view it as my job as a lawyer, and one of the things I always try to stay really crystal clear on as the lawyer is, what do you want? What do you want? What is your ideal outcome? If the situation is that you have a client that has skipped out on a $20,000 invoice, then what you want is you want that $20,000. But I think that oftentimes business owners start to take these things personally and emotions get involved. And whereas what they truly want is the 20 grand, other things start to seep in and other competing wants start to distract from the core want. And people start to feel like, well, I want an apology. I want respect. I want to be acknowledged. These are competing wants that are distracting from the core want. And the core want is you want the invoice paid. And it might be nice to have an apology. It might be nice to have respect, but that's not necessary to get the invoice paid. And that is what they actually want. And there's no guarantee that intimidation is going to accomplish that goal. In fact, depending on the personality of the person you are dealing with, intimidation is more likely to have one of two results. Either one, if they're conflict avoidant, it's more likely to cause them to shut down, to get scared, to cut off contact with you, and to just stop responding. And then if they are the opposite, if they love confrontation, if they love a good fight, they're more likely to get indignant. They are more likely to get aggressive. They are more likely to get their own lawyer up and say, let's do this. And guess what? Both of those results are more expensive for you. Both of those results have now created a situation where you're going to have to continue paying lawyers to resolve either one of those situations. You know, if the person just disappears and ghosts you, well, now you're going to either need to send that to collections or maybe get a lawyer to file in small claims court to go find this person because they have disappeared and ghosted you because they didn't react well to the intimidation. Or if you're dealing with someone who just loves conflict, now you've created a situation that's going to be dragged out, that's going to be ugly, that's going to be personal. And let me tell you, when lawsuits are personal, they last a lot longer, speaking from experience. So either of those results is not what you want. That's actually the opposite of what a good demand letter should do. So let's talk about the difference between a good cease and desist letter and a bad cease and desist letter. A bad cease and desist letter or a bad demand letter is one that is hastily written. There's not actually much concrete law or concrete fact there. The intention is really just to try to intimidate and strong arm the other person to do what you want them to do. And it usually has a lot of hyperbole and emotional language. That's a bad demand letter. That's a demand letter that creates problems instead of solving them. Now, a good demand letter, on the other hand, is convincing, it's persuasive, and it credibly tells the other person why it's in their best interest to settle this thing right now. Incredibly, convincingly, persuasively tells the other person, hey, these facts are on my side, these laws are on my side, these cases are on my side, it is well thought out, it is well researched, and it communicates to the other person, hey, I'm just going to level with you. If we go to court, I'm going to win. So it's in your best interest to come to the table and let's settle this right now. Or pay me the money you owe me, depending on the situation we're dealing with. That's what a good demand letter does. A good demand letter explains in a reasonable, logical, yet still firm, or sometimes funny, depending on who we're dealing with. You might have seen some of these, companies like Beyonce's team, Netflix getting creative with their demand letters, but it explains the situation. It makes it clear that your case is slam dunk, and it makes it very logical for the other person to understand that the best thing they can do is settle and give you what you want. That's what a good demand letter looks like. And intimidation cannot do that for you. Intimidation does not accomplish that goal, and that is why it is not a winning strategy. That's why just firing off a scary letter is way too simplistic, way too oversimplified, and just really misses the point, because the point is you want usually them to do something or to stop doing something, and it misses the point of that core goal. The third reason why just firing off a scary letter is not a winning legal strategy is because of the legal doctrines of laches and or acquiescence. Now, these are legal concepts, but basically what they mean is the following. Basically, it means this, that if you have actually known that somebody else was violating your legal rights, and if you've known that for a long time, like let's say like 10 years, you can't just, and in fact, you've just kind of let it go, and that action or inaction has led them to believe that you're actually fine with what they're doing, then you can't just wake up one day, change your mind, and decide to take them to court. You can't do that because you have acquiesced over the years. You have acquiesced to their activity. They have relied on your behavior, and you can't just wake up 10 years later and say, never mind, I want to take you to court and sue you for a bunch of money. That's an oversimplification, but that's basically what these legal doctrines mean. And so because of these doctrines, just firing off a nastygram with no real intention of ever following up on it can be a strategy that backfires. And this is something that happens in the area of intellectual property, for example, trademark and copyright. A company will send someone else a letter and say, hey, you're infringing our trademarks. And the other company will respond and say, we don't think we're infringing your trademarks. We think that what we're doing is fine, or it's fair use, or it's whatever. And then the original company just never follows up. They just never respond. And years go by. And the second company assumes, well, they never followed up, so I guess this is fine. And then if you try to come back years later and take them to court, the very first thing they're going to say is, hey, wait a minute. They sent us a cease and desist letter, years ago, and we responded. And then they never followed up. So no, this claim is barred by laches, or this claim is barred due to their acquiescence. And so this is another reason why, just kind of the idea that you can send off a letter, but you have no real intention of following up. You are not mentally or financially prepared to negotiate or to litigate or just to bring things all the way to the end, to a conclusion. This is why it's not a winning strategy. You could actually, in doing that, undermine your ability to bring a claim later. If you just fire off a letter and then never follow up with it, then, years in the future, when you are ready to deal with it, you could find that you're not able to. And that strategy actually backfired on you. So that's the third reason why firing off a letter but not really intending to follow up on that letter is not a winning legal strategy. And then last but not least, the reason why it's not a winning strategy to just kind of send a scary letter and hope that that's going to be a one and done solution is because of reputation. You do not want to be the company that is known for blowing smoke and never actually following through. And in this day and age, you can just go ahead and assume that if you send somebody a demand letter, there's a really good chance it's going to end up online. There's a really good chance you're going to find your letter in a subreddit. You're going to end up on someone's Discord channel. You're going to end up on X. There's a really good chance that letter is going to get posted online. And if it becomes known that you sent someone a demand letter telling them to stop doing something or telling them to do something, but then you never followed up on that, that's only going to embolden other people who are thinking about engaging in the same behavior. That's only going to make other people say, hey, wait a minute. They sent that demand letter to so-and-so, but they never followed up on it. They're not serious about their intellectual property, or they're not serious about their invoices, or they're not serious about whatever policy it is that you're trying to enforce. That is not a good look, and that is not where we want you to end up. And that is the fourth and final reason why just this idea of, oh, well, one and done solution, let's just send off a letter, is not a winning legal strategy. And this is why when people, companies, business owners come to me and they say, hey, can you just send a letter? And this is why I always say no, because the truth is that it doesn't end with the letter. I need to really be able to dig in and say, hey, we need to look at the evidence. Let's look at the dates. Let's look at the emails. Let's look at the laws. Let's look at the case law. Let's see what we have here. We're not going to do this halfway. If we're going to send someone a demand letter, we want to send the good kind. We want to send the kind that makes it clear that we have a really solid case. We're not just shooting from the hip. We're not just halfwaying it. We've done our research. We've done our homework. We know we can win. And because of that, that's why they need to do what the letter says. That's why. Because we've done our research and our homework, and we know we're standing on really solid legal ground here. And because we are willing to take things further if they don't do what we're asking them to do. That is so key because, again, you don't want to be the company that blows smoke and never follows through. All right. So that is what I have for you guys today. I hope this has been really helpful for you as a business owner, as a CEO of your company, to understand what a demand letter is and to understand when it makes sense and when it doesn't, to understand when it is a good strategy and what a good demand letter strategy looks like, and whether you're dealing with a situation like this now or you might be in the future. Hopefully this has given you something useful to take with you. And if you are interested in partnering with a law firm that believes in your business and is able to help you get legally protected, click the link in the show notes and set up a time to chat. And as always, thank you so much for being here, and I'll see you next time on the Legal Upgrade Podcast. Bye. Hey, thanks for listening to the show. The Legal Upgrade Podcast is a Bevel Law production. For more information about the Legal Upgrade, you can follow on Instagram at Bevel Law or find even more information on the website bevellaw.com. If you enjoyed the episode, please remember to subscribe, leave a review, and share it with a friend. See you next time on the Legal Upgrade Podcast.